All right, hi everybody, welcome back. Attorney Steve Vondran, welcome to another exciting episode of Litigation Whiteboard. Today's Thursday, February 20th, 2025. Today we're talking about California Central District Local Rule 37.1. Guys, when you're litigating in a foreign territory like California, you need to know the local rules. These are essential, especially where you have discovery disputes. These pop up in every case. There's discovery disputes. Almost every case I've ever litigated, we're talking hundreds now, have discovery disputes. So let's take a look. Without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, here we have it. All right. So when you're litigating in the Central District of California, there's a very important rule I want you to know about. Central District Local Rule 37.1, I should say. It's a meet and confer requirement. It's a very specific process that must be followed anytime that you're dealing with a discovery dispute. And the discovery disputes fall under any of these F.Rs.Civ.P, which stands for Federal Rules of Civil Procedure, Rule 26 on up to 37. If you have any disputes that arise in there, sandbagging on your interrogatories, sandbagging on the request for production of documents, any type of discovery that arises under this section Local Rule 37-1 applies. And you must follow this. It's very strict. And just be careful. If you don't follow, you may not get anywhere trying to get that discovery that you're really looking for and that you really need to prove your case. All right, so let's take a look. You got the discovery dispute. I just put sandbag. Sometimes you just get the worst sandbag from people, nothing but objections and no documents. I don't have anything, DDD. And you have a discovery dispute. Here is the process in the Central District of California. We are currently, by the way, Vondran Legal, we're currently serving as local counsel in a Facebook litigation. If you guys remember the allegations against Facebook, we're also involved in the FTX cryptocurrency litigation and serving as local counsel on both those cases. All right. So basically, first thing you're going to do when there's a dispute, you're going to do a detailed meet and confer letter, okay? You are going to spell out every interrogatory, every request that was not responded to your satisfaction and according to the law, of course, which they are required to respond to. You're going to be very detailed. You're going to put everything in a detailed letter. It can be laborious. It can waste a lot of time. It can take up a lot of time, consume a lot of time. But you got to go through the painstaking process to put down the issues where they fell short, where they did not disclose, where they're raising objections that have no merit. Like many times you'll see the boilerplate, irrelevant, not reasonably calculated. Just go, okay. So explain to them why it is relevant, things like that. But it's going to be very specific. You're going to identify each issue. You're going to state what your position is. You're going to cite any contentions that you have. You're also going to discuss memorandum of points and authorities. So in other words, you're going to put case law in there. You're going to say, according to this case, you need to provide this. It's a trade secret case. You need to show this. It's a right of publicity case. We're entitled to get this evidence of gross sales, whatever the case may be. Put your points and authorities in there, and then your proposed resolution. This is what we're looking for. This is what we want. If you don't comply, if you're not willing to voluntarily do this, let's set up the meet and confer call, what we call the Conference of Counsel, Local Rule 37.1, Conference of Counsel. Okay, so this is where it gets a little interesting. So they're trying to create this rule where attorneys will work together and maybe resolve their disputes. I know it sounds wishful thinking sometimes, but that they will resolve their disputes and will not have to file this motion. The motion takes up the court time. I mean, I've seen motions that are 300 pages long and then oppositions that are 200 pages long. Imagine what a court has to go through and the clerks and everything to come up with the right answer in these kinds of cases that in many cases they don't know a whole lot about. So you want this conference of counsel to try to whittle down the issues to the absolute essential issues, the discovery issues that are critical, that need to be responded to. So you have this conference of counsel. You send the detailed letter. The conference should occur within 10 days. This is a strict deadline unless the parties agree otherwise. Parties are free to kind of work something out a little more casually and cordially, things like that. So, but typically you're going to meet within 10 days. I have here same county. If you're in the same county, there is a personal meeting requirement. So you go to the party that's the moving party. The other party has to go to their office. Okay, so it's a personal meeting requirement. Something pretty unique. I don't see that in any other district, actually, aside from the central district where we love. Anyway, so within 10 days, you're going to meet and confer. You're going to get on the phone. You're going to see in good faith if there's a way to avoid the motion. Get on. If you're not in the same county, you can pick up the phone and you could do it via phone or Zoom or whatever you want to do. But if you're in the same county, don't forget there's that personal meeting requirement. Very important. And then in any declaration, you're going to want to say that, you know, that we held the meeting for council, a meeting of council, and it was in person and so forth and so on. All right. So within 10 days of the detailed motion, meet and confer letter, within 10 days, the council are going to meet, discuss, confer, try to resolve. If that doesn't happen, we move into what we call the stipulation process. This is where the parties have to get together, put together a joint stipulation. This gets filed with your notice of motion, a joint stipulation to identify each of the issues, each of the parties' contentions of law and fact, the points and memorandum of points and authorities that the parties have, the proposals to remedy the issues, so forth and so on. Okay, you can have exhibits, you can add declarations. If you go over 10 pages, don't forget you have to have a table of contents, not a table of authorities, but a table of contents. You have a 3-page intro max, so don't go crazy. You have one full 3 pages to do an intro. That's plenty of room for a good, well-reasoned introduction. Okay, so you put it together. The moving council will then, the moving party that wants to bring the motion, the discovery motion, will then send it to the opposing party. The opposing party will have 7 days to add their counter arguments, their counter exhibits, their counter declarations, their points and contentions, memorandum, this, that, and the other. Okay, so it's the same thing, but you have to put it together. Both parties sign this. You file it with the court. And don't forget, if you need a chambers copy, make sure you check your judge. If the judge wants chambers copy, never forget that in federal court. But that's it. Other than that, the opposing party has their time to add. You file the notice with the motion. After the motion's filed and prior to 14 days before the hearing, each party has an optional right to write up to a 5-page memo. So if there's something else you wanted to add without getting too lengthy, you can come back with a memo. So bear that in mind. But this is the general process to meet and confer, to handle discovery disputes here under F.Rs.Civ.P 26-37. Detail, meet and confer. Meeting of council may be an in-person requirement, the joint stipulation, preparing the motion, and so forth and so on. This is a general legal overview, not legal advice. But if you need help with local district, Central District, California, local counsel, you know where to find us. Woo. Attorney Steve Vondran. I hope you guys have enjoyed this. I love educating you guys and giving you some of the things that I find and learn in my practice of the law in over 20 years of litigation. If you like this, go ahead. Thank you guys. Have a great day. Bye now.